This is your teacher, Dr. Usama Kashwa, and this is our first lecture in the Canadian or the business law, and we will apply on Canada. So it will be the Canadian business law. Canadian business law. So let me share the screen and say what I have here in this topic today, and we share the ideas together. So what is the Canadian business law? And what are the contents of the Canadian business law? The reason for this chapter is to define the law, explore its origins, and examine methods of enforcement. Second thing, to outline the legal system and its procedures. Third, to survey methods of disputes resolution. If there is problems between people, how to solve these problems, and which are alternatives to court. Instead of going to the courts, how we will go for a solution for the problems with the people, with each other, how we can solve these problems. So those are three objectives. We'll talk about the nature and the origin of the law. Nature and origin of the law. A law is a rule which governs, regulates the conduct of persons and business. Do you think how a society will be without the law? How a society will look like without the law, without applying the law in each single movement and each time? How the society will look like? So society without applying a law is not a society. There must be law, acts, and rules that govern the behavior of the people in the society. In general, the law is jurisdiction-based collection of rules which impose penalties. Look at this, impose penalties. What do you mean by penalties? Like it's a kind of punishment. It's a kind of punishment. This is the meaning of penalties. When the rule is ignored or disobeyed. So if I do by breaching to the law, breaching to the law, or if I do like a kind of penetrating the law or going against the orders in a society, in that case, I am doing something wrong against the law. In that case, I deserve penalties. So in general, the law is a jurisdiction based collection of rules which impose penalties when the rules is ignored or destroyed. The function of the law. Why is there law? Why? The functions of the law include what? The protection of rights and privileges. So I apply the law to protect the people. Like you see in the cars of Toronto here, police, you see to save and to protect. So the first thing is the protection of the rights and privileges. Second, the restriction of rights and privileges. Third, the control and enforcement of rights and privileges. So protection, restriction, and control. Control of what? Control of the enforcement of rights and privileges. Okay, let's move on now. We know now why. Functions of the law means why the law exists, why it is working, because of these reasons, because of the protection of the rights and privileges, because of the restrictions of rights and privileges, and because of the control and enforcement of rights and privileges. This is why we have the law and the enforcement. Perfect. So we have now sources for the law. We have many sources for the law. Yes, we have the common law. The common law is originated in Britain. Its own originated basically. Common law was first to be seen in Britain and is used in all of the provinces and territories except for Quebec. In Canada here, it applies in all the territories except Quebec. Quebec got no common law. Okay. It is judge-made law based on the doctrine of precedents, meaning of use of previous judgments as an aid to later decisions. So as example, the judge will see a case in front of him, and he will look for a resolution or like a kind of judgment, but he didn't see. He will go back forward for similar cases were there in the law and what the judges had been there, what are the penalties, and he will apply by simulation. Like those, he will do. As example, someone steals by force and he has 3 years in prison. And that was 1950. I have the same issue now in 2021. So I will make a judge based on this judge. Then he will take also, if he steal like same, the evidence are the same, but only the time is a change, then he will do the same penalty and he will take the same penalty. So we measure something upon something happened in the past. We make them by simulation. So I will imitate what happened from 20, 30, 40 years, case happened. I will compare it to the what's happening now, and I will put my judgment as a judge based on this evidence or what happened. When cases have very similar facts, the decision of higher courts are binding. That's fine. When cases have similar facts, the decisions of higher courts are binding there. That's fine. So equity. The first thing we want to talk about, equity means all are the same in front of the law. All are the same. No one is better than anyone else. All are the same. So the equity, the law of equity also originated in Britain. The same thing in the court of Chancery. Okay, this was where started the law of equity. Means like all from equation, means all are the same. Okay, it was developed when the common law did not provide a suitable remedy through the provision of money damages. Okay, specific performance is an example of an equitable remedy from the court of Chancery. Okay, so this is the law of equity. Division of law-making authority. Law-making authority. Who will make the law? Who will make the law? It's formally divided the authority to make law between the federal and the provincial governments. So to put law, it's something in between the federal government and the provincial government. As an example, the federal government of Canada and the provincial government of Ontario, they will do together the make the laws together between the federal and the provincial. Like I said here, between the federal and the provincial. Okay. The subject matter of the law determines which government has jurisdictions. So here, what will happen in case of dispute, all this will be decided and said to be looked by or reviewed by this government, this courts in this province, and so on. The Canadian Constitution. The Constitution is a written book that governs all the country. It's the main, the big, or the great, or the supreme law that other laws work within it. Any country should have a constitution. All the countries of some underdeveloped world, first thing they do after independence is to have their own constitution. Constitution means self-dependence, means applying law, means moving into civilized country which apply the law and protect the rights by every article in it. The Constitution of 1982 consists of two parts: the British North America Act and the Charter of Rights and Freedom. The Constitution gives to the courts the authority to strike down government action that exceeds jurisdiction for contravenes the principles of the characters. So this is the Constitution. The Charter of Rights and Freedom, very important. The Charter entrenches the fundamentals and basic rights of the Canadians. The basic rights of the Canadians. So, like what? The right to vote and so on. The Charter cannot be changed or replaced except by an act of the Parliament, because the Parliaments are representatives for all the Canadians. So this is having the right. Approved by 2/3 of the provinces. So 2/3 of the provinces will approve on changing the Constitution and the charters. It's not easy to change the charters, which contains at least 50% of the population. So 2/3 of the provinces, but not any provinces count. And all of them will be not less than 66%, or say, let's say 50% of the total population. So small provinces together with the big provinces, they must be around 50% to apply any amendment or any change in the Charter of Rights. Rights are subject to reasonable limit prescribed by law, as can be demonstrably justified in a free and democratic society. The Charter, we're still in the Charter, the notwithstanding clause, Section 33, permits the government to enact legislations that overrides some parts of the Charter if its purpose is to achieve an important government goals. It's very clear. Again, the notwithstanding clause, Section 33, permits the government, give the government the power and the authority to enact legislations that override some parts of the Charter if its purpose is to achieve an important government goal. So it's left to the government to interact and make amendments if this is good for the will and for the will of the improving the Charter itself for a better, because of the needs of the people. After 5 years, such law expire, although they may be formally re-enacted by a government. Okay. Okay, the second part of law is the statute law. Statute is a law that arises from legislative process. Statute is a law that arises from legislative process. It is initiated by elected representatives, debated, and is approved, brought into force. If there is conflict between a statute and the common law, the statute law prevails. So the statute law is stronger than the common law. In cases of any contradiction between them, we will take with the rules of the statute law, but we will not take with the rules of the common law. It's supreme, it is overwhelming the common law. There are 3 levels of a statute law. We have federal law, provincial, and municipal statute law. We have 3 kinds of laws. Those are federal, provincial, and municipal. Municipal means locally, like the Toronto municipal here. Federal in all Canada. Provincial in each province, like Ontario, and so on. Okay. See here, like if I enlarge it, and I want to enlarge it so it will be appearing for everyone. Like here we can see now the provincial government and the federal government. The draft law called a bill, and there is draft law called a bill. Second reading, here is section second reading as well. Bill sent to committee to study. Here bill sent to the committee to study carefully also, and the change were necessary. Back to legislature of third reading, debated and changes made. Here back to House of the Parliament. So on the federal laws, it must go to the government, but the provincial, it's okay. But the federal law to be changed by the government. And this is the main difference between the provincial and the federal. Federal is of a vital importance more than the provincial, and the federal should be reviewed or amended by the governments. Okay. Canadian legal system, and this is another point. And this is another point. Canadian legal system. We'll get this back to its own place as it was, and that will be fine. So let's see about the Canadian legal system. The Canadian legal system, the rule of the courts. So what are the courts and the function of the courts in the Canadian legal system? See this now. The Canadian legal system, the rule of the courts. Okay, the judicial system is organized according to the geographical consideration, monetary amount, and jurisdictions by subject matter. A litigant commences a lawsuit in a court of original jurisdiction or a trial court. Perfect. If one party believes that the judge erred, made a mistake in the application of the law to the facts, in the severity of a sentence or amount, or in the amount of damages, an appeal may be commanded. So sometimes maybe the judge will make a mistake. The judge, if he made a mistake, you have the right to appeal. This is the meaning of the sentence. If there is a mistake, then you have the right to appeal, to make appeal. Okay. The federal courts. Federal courts are there on the federal level of the government. Federal means for all Canada, not parts of it, but for all Canada. Okay. The federal courts trial division handles subject matters such as taxation, patents, trademarks, and copyrights. This is the federal court trial division. Those are the things and the problems of the trademark and the copyrights, as well as appeals from a federal board and commission. So those are the specification of the federal court trial division. Take care, any problem regarding taxes, patents, or like the rights of patents, the trademarks and breaching the trademarks, imitating someone took someone's trademark and imitated, copyrights, okay, and those all under the supervision and the process of the federal court trial division. The second federal course or federal court type is the federal court of appeal. The federal court of appeal. hears appeals from the trial division. So, like we said before, if the judge make a mistake, then in that case, they will go for the courts to know about the problems and how to correct it. So here, the Federal Court of the Appeal, you can, again, if you are not convinced with the other court's decision and the judge's decision, and you suspect that the judge made a mistake, you can go for the appeal. So those kind of courts are for the appeal purposes. They hear appeals from the trial division. The third kind or type of federal courts in Canada is the Supreme Court of Canada. So the Supreme Court may hear an appeal from the federal court or appeal and from a provincial or territorial court to appeal. Okay. Now I want you to see this diagram. I will enlarge it first to make it very large. So like you see here, the Canadian system of courts, or the Canadian justice system, start with the Supreme Court of Canada. And like you see here, it's on the top of the array of the courts, Supreme Court of Canada. Then we have down it federal courts of appeals. This graph sum up all what we talked about before. So the Supreme Court of Canada, and those are the federal courts of appeal. Then the federal court trial division. The federal courts, those are the federal courts trial. And we said, whatever, if you are, as example, having a problem in a trial division, and you had a judge estimation, and you suspect that this estimation is correctly, and you doubt about this judge, in that case, you have the right to go to the Federal Court of Appeal and claim there. You will do appeal to check out the hearing and everything regarding the decision which was made in the trial division. Also, in this array, we have the tax courts. What about the tax courts? What are they for? Limited to appeals from tax assessment, not a true trial court. So tax courts is just for the taxes. Limit to appeal from tax assessment. It's regarding the taxes. And for that reason, because of disputes about the money, these are also, well, of the different types of the Canadian court system. We talk about now the provincial court system. And this is the second type after we talk about the federal court system. We move now to the provincial, from federal to provincial. We have the civil law courts. They have jurisdictions to hear disputes among corporations, individuals, and governments, and some are limited to special subject matters. So this is about the provincial court system, the first one, which is civil law courts. Small claims courts. So if you have a problem about a small amount, small claim courts generally have jurisdictions to hear disputes concerning, look at this, less than 25,000. So this is a small claims courts. If you have amount that is more than 25,000, then it is not the way for the small claims courts. Small claims courts, if you have dispute about amounts of money which is less than $25,000. The provincial supreme and superiors or queen bench courts, those here civil matters with an unlimited monetary jurisdiction. So 25,000 and more, this will be under the supervision of the provincial supreme or superior or queen's bench courts. Those all for any amount more than 25,000. Less than 25,000 will go to the small claim courts. We have also other provincial courts, including the criminal courts and courts of appeal. So we have also criminal courts and courts of appeal. Okay. How is the difference in between them? The criminal court, even from the name itself, criminal, from the name itself, criminal. What is it about? Deal with the criminal subject matter under federal status, as well as offenses under provincial from the provinces and offenses from the territorial status. So territorials are those in the northwest, like Yukon, Whitehorse, those areas. The provincials like Ottawa or Ontario, those we call it provincials. And municipal by law, like the city of Toronto. This is an example for the municipal by law. This is example for the city of Toronto. Okay, so these are the criminal courts. Again, the criminal courts deal with criminal subjects, matter under federal statutes, as well as offenses. So it is regarding the criminals and the offenses, crimes and offenses. Okay, under provincial or territorial statutes and municipal by law. The courts of appeal. So we have the criminal courts and we have the courts of the appeal in the province. But you told me that we have also courts of appeal on the federal level. That's right. So we have courts of appeal for the federal level and we have courts of appeal for the provincial. Yes, received, but the one of the provincial receives appeals from the province and territorial trial courts. So this deal on the level of province, but not like what we talked before on the level of federal or the federal level. This diagram shows clearly the system of the courts here in Canada. So we'll see that the Supreme Court of Canada will come on the top, then the provincial or territorial courts of appeal. So the Supreme, so if I have a problem and it's not solved in this level, it goes to the Supreme Court. If there is dispute or suspect or you need to appeal or whatever, then it goes out of here into the Supreme Court. So each level feed up the upper level, feed up the upper level. Each level will feed up the upper level. So here the provincial will feed the Supreme, and the division court and provincial from province, territorial, Supreme or Supreme Court. Okay, so those also will report to the provincial court of appeal. We have also small claim courts, which we said like less than 25,000. Surrogates, probate courts also, and provincial courts, magistrates courts or magistrate courts. All this will reflect, or if there is any disputes, they will go to the provincial courts of appeal. If it was not solved, then it will go to the Supreme Court of Canada. It will go to the Supreme Court of Canada. We said the criminal court and the court of appeal. Criminal court procedures. What will be done within the criminal court in cases of crimes? What will be done then? A criminal case is brought to criminal court by the Crown by one of two procedures. Less serious offenses processed or proceed by way of the informal summary conviction rules of procedures. So the offenses less serious and more serious offenses proceed by the way of indictment, which is a formal prosecution process. Criminal court trial. Within the criminal court, we have to check out if the accused pleads not guilty or pleads guilty. If he pleads not guilty, the criminal crime, to the charge, the Crown must prove that the accused committed the criminal act and intended to do so. Both the Crown and the defense counsel call witness. So expect that you will have to be asked as a witness in case you witnessed any crime. Of their cases, who are then subject to cross-examination by opposing counsel. After summation by the counsel, the court writes a judgment with the reasons explaining the verdict. Like, why did we accuse him? Why did we say that he is guilty? The court will do this. Civil court procedures. A civil lawsuit is commenced with an exchange of pleading between the plaintiff and defendant, detailing facts and claims. Examination for discovery are held under oath. So you will say the oath. You will have to say the oath that you are not telling lies or whatever. Recorded in transcripts, and the evidence contained in them may be used at the trial. So if there was evidences as example of any kind like robbery, a knife was used for robbery or whatever, in that case, it should be in the trial also as kind of evidence. Ordinary and expert witness are called by both parties and cross-examined by opposing counsel. Hearsay evidence is not permitted. Ordinary and expert witness are called, it's nice, both parties and cross-examined by opposing counsel. Hearsay evidences is not permitted. What is the judgment? The judgment is written by the civil court judge, providing the legal reasoning, a reason why of his or her own decision. So I took this decision, I gave this guy 3 years prison, and I will put the decision why I did so, the reasons behind this decision, and perhaps making an award of damages to compensate the victim for losses. So, and he will ask for, as example, if the victim lost a great deal of things, as example, lost his money, his car was crashed, so he must prepare himself to give or to compensate the victim in that case. Punitive damages may be awarded if the injury caused to the plaintiff was deliberate. So if the danger was able to be measured and the risk was there, and you can measure how far this person is damaged, then in that case, there will be punitive damages, and there will be awarded for these damages. As long as we can measure it, we can say in numbers, we can do it in numbers. An appeal may be committed if, for example, the judge erred in the application of law to the facts in the admission of the evidence. That's what we said before. Any mistake from the judge, you can appeal. Appeal means go to the higher levels of courts and say there was something wrong. Here is the something is wrong as example about the admission of the evidences. The evidences was not enough, and he depends only on these evidences and issued his own estimation and judge based on non-sufficient evidences or not enough evidences that support the decision. Administrative tribunals. Disregarding the administrative and the business work sometimes. So borders or board of commissions may perform functions similar to that of the court, but only with a jurisdiction of specialized statutes. Procedural fairness on the part of the tribunal is required in the conduct of hearing. Okay. A count or a court may quash the decision of a tribunal if the procedural fairness requirements is not met. Yeah. If its decision is patently unreasonable, or if the tribunal has exceeded the jurisdiction. The second point is the arbitration and mediation. If this is a kind of resolution for the problems, let us see an alternative to the court. So out of the court and out of the police stations and out of the dispute in the courts, we can solve this problem away of the courts. So it is an alternative process to the court's process. So what? For resolution of disputes. If we have disputes, we can go on a resolution for these disputes. So in commercial arbitration, both parties have a say in the selection of an arbitrator who hears evidences and make a decision that is binding. So in that case, as example, the contract disputes, particularly between business with long-standing relationships, can be resolved quickly without going to the courts. We will not go to the courts. And confidentially and without any expenses, because you will solve it out of the course and the fees and the costs and the fees of the lawyer. So you will, by the mediation or the mediation, you will avoid all these costs. you will remove this cost. So it will be this situation. If we solve the problem together without going to the costs, without going to the courts, in that case, we would save a lot of money, the money which will the lawyer take and so on. The rules of the legal profession. Legislation governs the legal profession, limiting the right to practice law to those who are formally admitted to provinces and territorial law societies. Following admission to the bar, lawyers are subject to codes of conduct in the practice of the profession. Law societies have the power to discipline lawyers who fail to comply with the codes. To sum up what we were talking about in this lecture, the law governs the conduct of individuals and the behavior of the individuals in a society and business through the government-made statutes and judge-made common law cases. Methods of dispute resolution include the court system. So if I have a problem, I can go to the court, administrative tribunal, or I don't go to the courts and I will solve it through the arbitration and the mediation by interfering a third party who will be able to solve the problem without going to the courts and without causing myself too much money. For business, commercial arbitration offers confidential, inexpensive, and speedy solutions. The arbitration is very nice because it will give a very quick solution for the problems, and at the same time, you won't stay in courts for years to solve your problem. It will be done within 1 or 2 sessions, which maintain long-standing relationship, and that will make a good relationship between the business partners and the business entities in this. So this shows how far the mediation is very important, how far this system of arbitration and mediation maintain very good, better than the courts, because it keep on long-standing relationship. Shall see you in the next lecture. Thank you so much. Stay safe and have a good day. Bye-bye, everyone. Bye-bye.